It's the Brian Lehrer Show on WNYC. Good morning, everyone. Well, one thing we can now say about President Donald Trump, he will go down in history for taking away one guy's red card and for taking away a lot of people's green cards. Despite the red card intervention, as you probably know, the U.S. men's soccer team was eliminated from the World Cup last night by Belgium, perhaps with an assist from karma. Then there was the Supreme Court decision 2 weeks ago that didn't make as much news as some more high-profile ones. The court ruled 6-3 that green card holders can be denied re-entry into the United States if they have merely been accused of certain crimes. They don't have to have been convicted. The immigrant in question had been accused of selling counterfeit shorts in New Jersey. That case, known as Blanche versus Lau, is one of 7 contained in an article in The Nation about important Supreme Court rulings you probably missed by the nation's justice correspondent, Elie Mystal. Elie supports some of these rulings and opposes some of them, we should say. Elie, if you know his work, will certainly make his opinions clear. We'll also revisit some of the bombshell rulings you did hear about last week, like why Elie says the transgender rights case ruling goes way beyond sports, and back to the red card, green card, why he was rooting for Iran to win the World Cup. Spoiler alert, it's not because he supports their government. Elie Mystal is the nation's justice correspondent and a columnist. He is also an Alfred Nobler Fellow at the Type Media Center. He's the author of 2 books, the New York Times bestseller Allow Me to Retort, A Black Guy's Guide to the Constitution, and Bad Law, 10 popular laws that are ruining America. Elie, always good to get your take on things. Welcome back to WNYC.
Hi, Brian. How are you? I'm busy fighting apparently all Europeans over the validity of American soccer. So that's been fun.
What do you mean, validity?
Because the Europeans are just like, yeah, the U.S. was always trash. And I was like, no. We played like trash, but the team was actually good and really could have given Belgium a better game in different circumstances.
Well, you know, I definitely know Americans who might have been rooting hard for the U.S. team last night. It sounds like you maybe did not fall away from that, except they lost their enthusiasm because of Trump throwing his weight around with FIFA to reinstate that player who got suspended for a red card foul. It was probably a bad call by the refs, but nonetheless, I think the sports exception to political polarization, and there does seem to be one. We certainly saw it in New York with the Knicks. It didn't matter, you know, what you thought about Trump or Mamdani or anything. Everybody was wearing the orange and blue. That sports exception got spoiled, and what people think about Trump became a factor for many fans last night, I think. Any thought about that, or should we go right on to the Supreme Court?
You know, I think it's the same thought, though. I think it's a perfect segue because what I saw from the admittedly corrupt decision by FIFA is that maybe people in the sports context can see that just because a judge or a body or an institution rules on something doesn't make that ruling right, doesn't make that ruling fair, and doesn't absolve that ruling from corruption. And to segue it into something that I think we'll talk about later, you get so many people who are just like, oh, see, kicking trans people out of sports, that's not unconstitutional because the Supreme Court said so. Yeah. Check the source, right? Check which Supreme Court justices said that, right? And people need to. I thought it was karmically interesting that the most American way to play soccer involves suing to object to a bad call, right? And then getting a corrupt decision from a ruling body. Like that seems so very American to me in this moment.
And I did see after their win last night, the Belgian team put a 2-word post on social media, overturn this. But before we leave soccer, I do want to give you the chance to say why you were rooting for Iran, which, like the United States, has been eliminated. Why for their World Cup team?
Because their World Cup team was playing under the worst circumstances of any team in the tournament. First of all, their own government didn't let some of their best players play on their team because some of their best players were not sufficiently genuflecting to that government. Given where I live in this country, I can understand that. So they got screwed by their own government. Then our country, one of the host countries, starts an illegal, unconstitutional war against their country. That's not cool. Then, despite the fact that this World Cup was being hosted across 3 different nations in North America, the FIFA made Iran play all of its games here, which is ridiculous. And then this country refused to grant visas and travel permits to all of the team's staff and members. So that's ridiculous. And then when they were forced to base their team in Tijuana, fly to the U.S. for all their games, this country was forcing them to immediately fly back to Mexico after the game, not even allowing for the normal athletic recovery time overnight. You get your ice bath. No. None of that. As soon as the game is over, bam, they were back on a plane to Tijuana. That team played under ridiculously bad circumstances because of 3 governing bodies: Iran, the U.S., and FIFA. And I so wanted that team to overcome that in any way they could. Just being here was overcoming some of those hurdles. And I wanted them to do as well as possible.
Talk about playing soccer with one leg tied behind your back. The one on that list that I didn't realize until I read it in your article was that all their games were scheduled for on U.S. soil, even though there were venues that were also hosting and are also hosting World Cup matches in Canada and Mexico. It's a North American, wide World Cup. Do you have any indication that FIFA did that, maybe at the request of Donald Trump, specifically to inconvenience the Iranian team as much as possible?
No, I don't. FIFA makes these schedules a long time out in advance. And they were just being inflexible and unreasonable about the situation. I think that's more on FIFA and less on direct U.S. corruption.
All right. Blanche versus Lau. Muk Choi Lau was a green card holder, a legal permanent resident who had briefly gone back to China, but when he tried to return to the United States, want to pick up the story from there?
Yeah, Brian, first of all, I'm so thankful that you are highlighting this particular story, because it's honestly one of the worst decisions that happened in the last 2 weeks of the Supreme Court turn, and most people missed it, right? So yes, this Chinese, born Chinese national who has an American green card, so he's a legal person, permanent resident, gets charged with a counterfeiting charge, right? It's a crime. It's a minor non-violent crime, but he's charged with a crime. He pleads not guilty. And he returns to China to visit family, and then attempts to come home to the U.S. As he is allowed to do because he's a green card holder. He's stopped at the border by border officials who refused to allow him re-entry into the country because of this pending charge. Now, at the time that he was denied, this is just a charge. He's not been convicted of anything. Indeed, he's pleaded not guilty to this charge. Nonetheless, he's denied reentry, and told that to get back into the country, he has to apply for reentry as opposed to simply coming back because he's a permanent resident, right? They eventually parole him back into the country, specifically so he can resolve his court case. He ends up pleading guilty to the counterfeiting charge, which again is a crime. But that is not a crime, counterfeiting, that gets people deported, right? If you're a legal permanent resident, you can't be deported just because you've committed counterfeiting. However, because the man's status was changed from legal permanent resident to applying for reentry, counterfeiting is a charge that can get you denied a visa in the first place, if you will. And based on that, they kicked him out of the country. They deported him. He sued. It goes all the way up to the Supreme Court. And 6-3, the court rules that, yeah, that's fine, that you can deny a person entry, not based on a crime, not based on any evidence of a crime, but based on mere charges, based on mere allegations. That is enough to kick a person, to deny a person reentry to the country, and that you can be denied reentry even if you are a legal permanent resident. It is a gross and disgusting decision, and really shows just how extremist not only the Trump administration, but his cabal of justices on the Supreme Court. It shows how extremist they've become and uh, uh, how much they disregard even the basic tenets and spirit of the laws.
You know, one of the reasons I keyed on this case is because it seems to me to have implications, at least, and you'll tell me if you think it establishes law in this respect, but implications beyond this case. Can someone be deported or denied reentry just because they've been accused of a crime, in this case, as you say, selling counterfeit shorts in New Jersey, without having been found guilty? And I read into this a little bit, and I saw that Justice Thomas wrote in his majority opinion that, quote, the government may regard a lawful permanent resident as seeking admission as soon as he committed a crime involving moral turpitude, even if the conviction occurred later, unquote, from Justice Thomas. So he really said it very explicitly right there, right? That expressly equates committing a crime with being accused of one if they don't have to wait for conviction to make that judgment, right?
Yes, Brian, and I thought that that was particularly rich coming from Justice Thomas, who has been accused of a thing or two in his history, right? Justice Thomas and Brett Kavanaugh are two justices that know a thing or two about mere accusations. And yet accusations have not stopped them in their career trajectory. Accusations have not stopped them from holding inscrutable, unaccountable lifetime power. And yet, for the little people, for everybody else, a mere accusation by this government apparently removes even basic due process before the government is allowed to act against you. So I absolutely think it has larger implications beyond the case of legal permanent residence of a green card holders. But Brian, by the same token, we've already seen the lack of due process when it comes to people detained in these government immigrant detention centers or concentration centers, right? We've already seen the denial of due process, people rounded up on the suspicion of being an illegal immigrant, on the suspicion of being undocumented, on the suspicion of being out of status, and then denied their due process rights, and in some cases put on a plane before any lawyers have had a chance to plead their cases, right? So the lack of due process rights is usually not something that makes people riot in the streets, but it is kind of the definition of encroaching fascism, right? It is the point where the government can say, it's the Spanish Inquisition, right? It's the government can say something about you, and you have no reasonable opportunity to defend yourself.
Yeah,
that is America right now.
And my question about how broadly this applies is that this case was about letting a green card holder return to the country from outside. Does it now also apply to these cases you were just referring to, deporting any immigrants who are here who are merely accused of things who the government would like to remove?
I think it will. I don't know that yet. That's not the law of the land today. But do you want to be the green card holder who tries it, right? Because how does that situation that you just explained, Brian, become the law of the land? Well, it happens to somebody. Somebody says, hey, that's illegal. They appeal their case. It gets up to these same 6 Supreme Court justices, and they make the same ruling, a similar ruling to the one they made last week, right? Like that's how this thing that is illegal now becomes legal the first time the Trump administration tries it.
And I seem to remember Trump being accused of high crimes and misdemeanors on 2 occasions by the House of Representatives, but the Senate didn't convict him, so he couldn't be removed. I guess the same standard doesn't apply to those others. But listeners, who has a question, a comment, or a story for Elie Mystal, Justice Correspondent for The Nation, 212-433-WNYC, on any of the Supreme Court decisions from this term? We're going to move on now from Blanche versus Lau. Maybe even other legal issues. There are so many in play in the Trump era, or maybe even on big think questions for the nation's 250th birthday 250 years and 3 days now, that I hope we'll have time to get into, including the social and economic rights that Elie writes are missing from the United States Constitution. 212-433, WNYC 212-433-9692. Call or text for Elie Mystal. Next case, National Republican Senatorial Committee versus Federal Election Commission. You call this the most important case about democracy since Citizens United. How come?
Did you all like Citizens United? Did you like the part where the Supreme Court said that money can corrupt politics? Well, this is Citizens United 2. The Electric Boogaloo, right? This is Citizens United off the chain. What it allows for is dark money, the kind of uncapped spending that people usually give to super PACs who then support various candidates. What this decision says is that those super PACs can now directly coordinate with the candidates of their choice, kind of eviscerating any real difference between light money and dark money, right? Like, because now you give your money to the super PAC, and you're not really giving it to the super PAC, you're giving it directly to the candidate of your choice. Now, that has always been true in some level. That's why we call it dark money. But the Supreme Court is kind of obliterating, for all intents and purposes, that distinction and allowing super PACs to directly coordinate with candidates. So if you're Peter Thiel, this is great. This is great, right? You've always had to keep your boy, your sock puppet, J.D. Vance, at like an arm's length to at least keep up the appearances of legality. Now you don't have to do that, right? Now you can just roll in with your billions of dollars and stick your hand up J.D. Vance's backside and tell him exactly what to say, which again has probably been happening for a while, but now it's legal.
Let me ask you to be you were very clear right now, but I was left after seeing the initial news coverage of that case, and I was off when it came down. So it's just based on what I read. But what Citizens United did 15 years ago was to allow independent groups who support or oppose certain candidates to spend unlimited amounts of money in those races. But they couldn't coordinate explicitly with the candidates. That's what you were just describing. And yes, when we've done candidate forums here in the primaries, we've heard candidates from left and right, to be fair, use that distinction to distance themselves from unpopular outside groups who spend money to support them, or just mysterious dark money outside groups who spend money to support them. Does this ruling mean the special interest groups could now coordinate with candidates to their heart's content, or is that wall still up to some degree?
There is no wall. That wall is down. That wall has been perforated. That wall has been cleared. There is no wall. Now, you might have, Brian, candidates on your program who still claim they're not coordinating with these dark money outside groups. So I don't know nothing about birth and no babies. Like, you still might have candidates who come on your show and say that. And they might not be lying, but they might be lying. And the point is that before they could argue they're not allowed to coordinate with those outside groups. Now they're allowed, and they'll just be asking you and your listeners to take their word for it that they're not.
Could there be a political silver lining here in a certain way? If an interest group is officially coordinating with a candidate now, unless they lie in the way you just described, can the candidate not wriggle out of being associated with them by saying, oh, I can't control what outside groups do?
Yeah, no, because not really, because they can still credibly say they can't control what outside groups, like if the outside group doesn't want to coordinate with the candidate, they can't force them to, if you will, right? So again, I think this gives even more wiggle room for candidates as opposed to boxing them in, right? Because the outside groups can coordinate with them, but they don't have to coordinate with the outside groups if they don't want to, or if they say they don't want to. And I think that the biggest issue is that there's no way to tell, right? There's no way to prove it. There's no transparency here. They don't have to say what they're doing or not at all. That's not part of the law. It's the law is focused on what the outside groups can and can't do, not on what the political candidates must do. And that's the biggest loophole here, right? It gives outside groups all of this power and influence, but no accountability for the candidates themselves. That's why our system is going to be even more corrupt going forward than it has been. And that's a ridiculous thing to say, given how corrupt it's been in the past, but it's only going to get worse now.
Before we move on to the next Supreme Court ruling that you wrote about, politically speaking, anger over big money in politics, I think it's fair to say, is one of the biggest driving forces behind the wave of DSA and other populist candidates who've been winning Democratic primaries this year. If Democrats come to control Congress and maybe the White House in coming years, could they do anything about this ruling or Citizens United itself? Or are these now out of political reach because the court ruled them protected by the Constitution?
Well, now we're getting into something that I really want to talk about. This, I think, should be the first test case for what's called, in the legal jargon, jurisdiction stripping. That is the idea that the Supreme Court does not have the constitutional authority to be the sole and final arbiter on what is or is not constitutional, right? The theory is that Congress can write a law, say that the law is constitutional, and prevent the Supreme Court from reviewing or potentially overturning that law. And I think, given the popular outrage at this rampant and rank corruption in our politics, if Democrats take back Congress and the House and the Senate, the first bill they should pass is a law overturning NRCC, overturning Citizens United, and saying in the law the Supreme Court's not allowed to review that. I think that should be our first test case. Now,
boy, that would be a huge change, right? Saying that the Supreme Court does not have the final say over constitutional questions.
Yes, it is. It is a nuclear option, if you will forgive a turn of phrase, right? But I think this is it. I think this is where we should start.
There are a few more of these under radar cases where you like the Supreme Court's decisions. And a listener is writing in about one of them. Listener writes, I clicked on the wrong text there. Let's see. Would Mr. Mystal please comment on Chattree versus United States regarding short-term surveillance of location data? So why don't you do that? You call this a massive win for anyone uncomfortable with the surveillance state. Tell us about Chattree versus United States.
Yeah, this was a good case. This is 7-2, good guys win for once, in my opinion, of the good guys. And to me, the good guys are people who want the Fourth Amendment to exist, right? And the Fourth Amendment prohibits unreasonable searches and seizures, right? But we always have a legal kind of debate and fight over what constitutes a search in the first place. In Chattree, this was a situation where the police were trying to solve a robbery. And to solve that robbery, they asked Google for location data within, I think it was 150 meters of the scene of the crime, right? So they wanted the location data from everybody's cell phones that entered into what's called a geofence of 150 meters around the scene of the crime within a certain period of time, right? They issued a warrant on Google. Google submitted to the warrant. They gave them the data, and based on that data, they were able to identify a potential criminal, and that person was eventually convicted largely on the strength of this geofence data. Well, the person who was convicted argued that that was an illegal search against him. Now, previous to this case, these searches were thought to be searches against Google, right? Google has the information. We're searching Google. But he's like, no, you're searching my cell phone. And that's how you got it without a warrant. You got it without my consent. You searched my data, and that should be actionable under the Fourth Amendment. And the court, 7-2, agreed. And that is huge, because forcing the government, forcing the surveillance state to at least admit that they are searching you and not the big nameless, faceless ISP providers or whatever, that is an important shift in the law. Whether or
So the
not the search is
uh-huh.
unreasonable is going to be still an open question. Like the case got remanded, so we'll have a new trial about whether or not, or a new motion about whether or not that search itself was unreasonable. But simply forcing the government to make a showing that the search was reasonable as to you, the cell phone user, as opposed to as to Google, the cell phone provider, that is a huge change and a big win for privacy
Yeah,
advocates,
so
and I think for everybody.
your location data, if you have it turned on, is at least now we can say a topic that's covered under the Fourth Amendment. Here's a text with a question about the political donations case. Listener writes, isn't the really terrible impact of the Super PAC ruling that this dark money now has full access to the discounts on advertising afforded to campaigns? Have you thought about that?
I have not thought about that. Oh, would they? That listener might be right. They might actually also have that ability. I mean, if they do, at least in that, to go back to your earlier hypothetical, Brian, at
Mm-hmm.
least then the candidate won't be able to say, "I have no idea what they're doing." Right? Like that would be a way to tie the candidate to the dark money, if the dark money is getting the same ad rates as the candidate's campaign, because they shouldn't be able to get those ad rates unless they are. It is at the behest of the candidate, I believe. But no, I haven't fully thought through all of the implications of the advertising rates. I mean, look, we're talking about billionaires. I don't think that they particularly care about playing, an extra the 8%. But yeah, that's another aspect of it for sure.
Another ruling you like was in Watson versus Republican National Committee. This is generally known as the mail in ballots case. You call it probably the best decision that Justice Amy Coney Barrett has ever written. We did cover this one on the show and it came down. But tell us briefly what you think the court got right here.
Yeah, so the court got the idea of choice correct, right? Really it comes down to when does a voter choose their candidate, right? When does a voter choose who they want to be elected? The court said they make that choice when they fill out the ballot, not at some later date when the election officials receives the ballot. They make the choice when they fill out the ballot. And so if they fill out the ballot before election day, that choice should count regardless of when the post office gets off its pony and gets the ballot to the election official. And I think that is fundamentally right. I think that the four justices in dissent, it was a 5-4 decision, with Alito writing the principled dissent. And I think it's not surprising that Alito, who wrote Dobbs v. Jackson Women's Health, doesn't understand choice, doesn't understand when choices are made, and thinks that the government has to approve a choice before it's valid, right? That's very Alito to me. But Amy Coney Barrett, writing for a 5-4 majority, where she and John Roberts joined the three Democratic justices, she said, no, the choice is made when the voter fills out the ballot, and the law allows for the states to receive that ballot at some later date after election day. The other important thing here, though, is that and this is why I think you ultimately got at least two of the Republicans, is that this is really a case about states' rights. It's a case about whether or not Mississippi, in this case, has the right to determine when it receives its ballots, when a ballot is still valid, when it gets to the elections office, right? New York might have a different rule. California might have a different rule. North Dakota might have a different rule. It's about Mississippi allowing to conduct the election in the manner that makes sense for Mississippi. So if you don't like the Mississippi law, you can just change the Mississippi law. The mail-in ballots case does not mean that mail-in ballots have to be accepted. It just means that it's the states, not the federal government, that gets to make the determination on whether or not mail-in ballots are effective or accepted. And that could have an implication on the SAVE Act that Trump is desperate to pass, this federal regulation that would, force voter ID and get rid of mail-in ballots and all the kind of crazy election coup crap that Trump is into. A ruling like the mail-in ballots case suggests that the SAVE Act might kind of be unconstitutional on arrival, according to five justices on the Supreme Court, because it
Huh.
overwhelms states' rights to control the time, place, and manner of their elections.
Interesting that you said Justice Barrett's ruling on this is good in your opinion because it supports the idea of choice. It's the first time I can remember anybody calling Amy Coney Barrett pro-choice. But
Right?
you definitely piqued a listener's interest with your suggestion that Congress pass a law kind of overturning Citizens United and using it as a test case to strip jurisdiction from overturning that law from the Supreme Court. Listener writes, regarding a test case to strip jurisdiction from the court, wouldn't the court simply rule that any law stripping its jurisdiction is unconstitutional? Despite the fact that the Constitution does not deny Congress that authority, wouldn't they simply make a ruling in their own favor? What do you say to that, listener?
And now we play our game, right? Which I like to call Civil War III. This is the this is why jurisdiction stripping is a theory and not a reality. Because yes, I imagine that the minute you pass your law saying that the Supreme Court doesn't have the authority to review it, the Supreme Court says, "What? Yes, we do." And we overturn that law. And so then who wins? And then you are kind of in a situation where certain states would follow the laws as passed by Congress, and certain other states would follow the laws as passed by the Supreme Court. And then you have the beginnings of a conflict. The reason why I think campaign finance is a really good test case here is because it doesn't become this state government's going to do this and that state government is going to do that. It becomes this candidate is going to do this and that other candidate is going to do that. And giving how much people abhor the open corruption in politics, it becomes a much more interesting political decision. I'm a candidate, I've got all this dark money, but my opponent is following the law, following this theoretical law passed by Congress that eliminates Citizens United, that eliminates dark money. Am I going to ignore that law? Well, maybe the public will take that out on me. Maybe the public will hold me to account for that. And so you put yourself in a situation again, I'm like, if it sounds like I am in 3D, 4D chess mode, like yes,
Yeah, you are in the
but
weeds.
right? But in 3D, 4D chess mode, it becomes an opportunity for jurisdiction stripping to be accepted by the public and for the people against jurisdiction stripping to be punished by the public in electoral politics in a different way than just about any other kind of law or issue you can think with jurisdiction stripping, right? Like if you do it with abortion rights, you're just in a situation where blue states allow abortion according to the law passed by Congress, and red states don't allow abortion according to the overruling of that law as by the Supreme Court. And we're basically in the same situation that we're already in, right?
Don't
But with
don't
campaign finance, I think it can be very different.
don't we already have some jurisdiction stripping laws that have worked in Trump's favor? Or you tell me, maybe these are in another category. But haven't we seen the Supreme Court rule multiple times, like I think maybe on immigration cases, that, oh, we don't have the jurisdiction to even rule on this immigration policy of the Trump administration because the law that was passed governing it said it's not reviewable by the courts. Am I remembering that right?
I think you're more thinking about gerrymandering cases where the court has repeatedly said that political gerrymanders are non-justiciable, right? This is Rucho v. Common Cause, where Robert says that if you are gerrymandering your state for political advantage of one party or the other, the Supreme Court can't review that case. And so that is a similar thing to what I'm talking about. However, the difference, of course, is that this is one the Supreme Court says, I don't have the power to do this. Oh, well, good luck winning an election ever again, Democrats. Nothing we can do. Sorry. Right.
Yeah.
What I'm talking about is not the Supreme Court ceding power. I'm talking about Congress taking power
Got it.
from the Supreme Court. And that's very different.
Now that we've gone to third degree and fourth degree chess, we're going to take a break and come back and maybe hit fifth degree and sixth degree chess with Elie Mystal, justice correspondent for The Nation. We'll get a little bit into the transgender rights ruling, which he said goes much further than on sports, which is the only way that you may have heard of it before, and a very high concept thing that he wrote that I keyed on in one of his other articles about what's missing from the United States Constitution on this 250th birthday week of the country that he thinks might be put in there. Stay with us. Brian Lehrer on WNYC. Brian Lehrer on WNYC as we continue for another few minutes with Elie Mystal, justice correspondent for The Nation, who has written a lot about the Supreme Court decisions that came down in the last few weeks and really the last few months, including one that we've been going through some of the particulars of that were on 7 decisions that he said didn't get the headline treatment that maybe birthright citizenship and some others did, but that he thought were worth revisiting. I do want to get your take on the transgender rights ruling, which you wrote about in a different article. This is the one that allowed Idaho and West Virginia to ban trans women from competing in women's sports. Most of our listeners have probably heard about that ruling, at least the basics. But your article on that said the ruling goes way beyond sports. How so?
There are 2 parts to the ruling, right? One is the Title IX claim. Title IX protects people from gender discrimination. The court ruled 9-0 that these trans women athletes had no right under Title IX. And that does not stop at the athletic field. Title IX protects against gender discrimination everywhere, in the workplace, in the public sphere. And the Supreme Court saying that they have no rights under Title IX means that that will be translated into the workplace and the public sphere. I think the court is completely wrong about the Title IX analysis because they were saying that it's not sex discrimination, but it is, in my view, gender phenotype discrimination, which is already illegal under Title IX. The gender expression discrimination is you girl cannot be on the cheerleading team because you're not blonde and cheerleaders are blonde. The court has already ruled that that is discrimination under Title IX. I think this is the exact same thing. You, trans girl, cannot be on the team because you don't look like we want you to look, is essentially what they're arguing. And if you can do that on the athletic field, you can do that in the workplace. But the bigger issue is the 6-3 part of the ruling, which said that transgender athletes have no rights under the Equal Protection Clause of the 14th Amendment. Folks, I have reluctantly come to understand that advocating and defending trans rights is controversial for some people. I don't know why, but I understand that it is. The idea, if you think that you can take away somebody's equal protection rights, the literal right to argue under the 14th Amendment that they have the same rights as everybody else, and think that that just applies to volleyball, you're insane. That is not how this is going to work. And we have seen the blueprint for how they're going to do it with the affirmative action decision. If you remember, the decision overturning affirmative action technically was just about affirmative action and college admissions. But we've seen the Trump administration use that decision this is a point that was made to me by NYU law professor Melissa Murray. We've seen how the Trump administration has used the affirmative action decision in DEI hiring programs across the federal government to cut off funding from NGOs and other institutions who they allege practice DEI in some way that they can't even define. We've seen that decision metastasize across governments and across state governments. That's the same thing that's going to happen with this trans decision. So it's gonna start with girls volleyball, but it's going to end up in whether or not trans people have a right to exist in the workplace alongside everybody else. It is a disgusting decision and a gross revocation of basic constitutional rights for everybody, and it must be fought.
There would be a very different kind of argument, though, right? Because a lot of people support a ban on trans women in women's sports because they think there's a biological unfair advantage there. And I know that can be debated, but in some cases that is the case. You can't say that when somebody's applying to be a lawyer or a nurse or something like that. So how could it be generalized in the way that you just predicted?
Yeah, see, this is the thing though. They want a carve out. People think that you can take away rights from people in one area, but not take away rights from people more generally. And that is not how our laws work. And again, we've seen that not only with the affirmative action cases, but we've seen it with lots of LGBTQ plus cases in the past, where once you have the wedge, once you get your foot in the door of taking away somebody's rights, that those wedge issues then cascade against that group of people across a number of factors. So sure, go on to court and say, well, I don't think they should be allowed on the field, but surely they should be allowed in the workplace. And good luck making that argument to the kinds of bigots who are willing to make this argument in the first place. That's your problem. And that's always the problem. And again, I am not speaking extemporaneously. I am not speaking theoretically. I am just telling people how it has worked in the past. What we've seen when this is done to any group of people, we see it never stays on the issue that got the initial victory. We always see it metastasize and grow and spread like a rights-eating cancer across numerous fields and industries. And the same thing is going to happen to transgender people here. It starts on the athletic field, but it's very soon. You're not going to be able to go to the bathroom. You're not going to be able to participate. You're not going to be able to apply to be a nurse. It's gonna infect our society, which is how racism works, which is how bigotry works, which is how sexism works. It infects things. It infects what you think you hold dear. It will take that away from you too. So while it seems to some people an easy case, so, well, we're just going to take away some of their rights in this one area, it never stays there.
One thing that I think a lot of people may misunderstand about the sports ruling itself, and, you know, I heard a right-wing sports talk host on the day the ruling came down cheering, yay, that's it, no more men competing against women. But it's not that clear, correct me if I'm wrong, because it allows states to make their own determination. So this was about Idaho and West Virginia, which wanted to ban people-born men from participating in women's sports, but around 20 states do not currently ban all trans girls and women from female sports teams. Different states and also different leagues have different standards. Like the LPGA allows in pro golfers in what they call ladies professional golf who are trans if they had gotten treatment early enough that they never went through male puberty. So states and leagues can still set those rules as they see fit. The Supreme Court did not bar them from doing that. Do I have at least that much right?
Yes, Brian, but clip that and then bring me back on in 2028 or 2029, and we'll talk about that. We'll talk about how you are now made wrong by the future, right? Because, yes, this case was about whether or not discrimination against trans people was allowed, right? Can you discriminate against trans people in West Virginia, in Idaho, what have you? The next case is going to be about whether or not discrimination against trans women is required, right? So a blue state that allows trans people to participate. The next thing is going to be the government, the Trump administration, forcing those blue states, again, saying to those blue states, you can't allow that kind of diversity. And they will sue, and the court will be ruling on whether or not blue states are forced to discriminate against trans women. And that's going to be the fight we're going to have next. And guess what? You're going to lose it. So again, when I say this doesn't stay on the athletic field, I should also say this doesn't stay in West Virginia. This happens now in California. This happens now in New York, because that's going to be the next fight, whether or not discrimination is not merely allowed, but required. And that's what's coming next.
We're almost at
And
it.
I keep saying the one other thing I want to say is that I keep talking about trans women because that's who the discrimination is happening against. You'll note that this isn't happening to trans men. Trans men are allowed to compete and be wherever they want, but it's only trans women that are facing this kind of discrimination, which again, to me, shows that it is a point and click equal protection violation because trans women are not equally protected as trans men, even to say nothing of cis women and cis men.
Right.
But
And the other side
nobody seems to care
would
about that.
go around with you and say, well, there isn't the same statistical, on average, biological advantage in that direction, but we'll let that
And
argument play out.
I really
Okay.
get sick of that argument because, look, I was at varsity football practice when I was a 14-year-old kid, right? And I got lit up. I got snot bubbles out of my nose from a 19-year-old kid who had been held back a year. Could I say, hey, ref, check that man's hormones? No, it's sports. It hurt. I got up and I competed again. And I think it is fundamentally sexist and patriarchal to argue that a girl can't take a hit. They can. That's part of a contact sport. But that's a different issue, I suppose.
We're almost out of time with Elie Mystal, Justice Correspondent for The Nation. You wrote a big think article for The Nation's, America's 250th birthday that I definitely wanted to get your take on because I think it's so interesting and it has such big implications if anybody were to act on it, regarding racial inequality under the law and a high concept takeaway of yours that the core failure of our Constitution is that it's based on individual political and civil rights with no mention of economic or social rights. Can you unpack that distinction?
When you look at modern constitutions, that's constitutions that are written after ours. What you see is not just this kind of capitalist government, get out of my back, get out of my pocket, let me be who I can. What you see with modern constitutions is the inclusion of both social and economic rights, right? Rights to dignity, rights to habitability, rights to the environment, like all of these kind of soft rights that we need to live are actually put into modern constitutions in a way that our ancient, antiquated constitution did not contemplate, right? And that is its core failure. The way that I put it in my piece is that our constitution is all about negative rights, right? It's about what the government can't do, right? They can't do this, they can't do that, they can't take away this, they can't prohibit that. Our Constitution does not have positive rights, what the government must do, right? The easiest way to think about this is the right to vote, right? We have a bunch of stuff in our Constitution saying that the government cannot deny the right to vote on account of race, gender, what have you, right? We don't have a right that says you have a right to vote. That's actually not in the Constitution. We don't have a positive right to vote. And we don't have anything in the Constitution saying, and the government must make sure that everybody has a right to vote. And that's why the government can diminish the right to vote, dilute the right to vote, make it more difficult for people to vote. You should have a Constitution that says, no, you have a positive right to vote, and the onus is upon the government to make sure that right happens, right? And if you can think about that in terms of the right to vote, hopefully you can think about that in terms of across of a number of areas. You have a right to health care, potentially, right? You have a right to habitability of your environment. You have a right to a living wage. You have a right to dignity. You have a right to equality, right? So if you think about positive rights.
So Congress can pass such laws to that effect, but it's not guaranteed. They're not guaranteed in the Constitution, is your point.
All the government has to do is not affirmatively take those rights away. They don't have to do anything to make sure that those rights are accessible. And it's one of our core failures.
Elie Mystal, the nation's justice correspondent and a columnist there. He is also an Alfred Nobler Fellow at the Type Media Center. He's the author of 2 books, the New York Times bestseller, Allow Me to Retort, A Black Guy's Guide to the Constitution, and Bad Law, 10 Popular Laws That Are Ruining America. Elie, thanks very much for today.
Thanks so much for having me.
WNYC's journalism and storytelling is heard by millions of passionate listeners. Sponsors of our programming gain our listeners' attention and their respect. Learn about how your organization can support WNYC and WNYC Studios at sponsorship.wnyc.org.
The United States is about to mark its 250th anniversary.
And so on the Global Story podcast from the BBC, we're telling surprising tales of American influence on the world stage and in ordinary people's lives all across the globe.
We have this ability to export our story, and a lot of people have bought it.
I feel like the American dream is alive but not well.
From the BBC, it's the United States at 250.
Listen wherever you get your podcasts or find us on YouTube.